Thank you, Mr. Speaker. Well, as we close today, let me thank everybody for their contributions, challenging as that may be to extend it to everybody. But nevertheless, people are entitled to express their views, and that has been done very forcefully by members. It has been a passionate debate, and I think that's right. It should be a passionate debate because we're dealing with the value that we place on life, the very serious issue of disability discrimination. And I also want to take a moment in thanking members for contributions to thank all of those people that have written to us, that have emailed, they've called my office and they've shared their stories, and that's been, I suppose, the most humbling part of this experience, that this has given a platform to many families to speak about how much they love their child that has a disability and what they mean to them, and we have heard many stories in that respect. And it's because of them that this bill has been brought forward. But, Mr. Speaker, when I do look at this bill, and I think it was my colleague Mr. Lunn indicated how short the bill is, and yet this debate, for some members, has taken us into loyalist paramilitaries. I think that was Dr. Archibald talked about loyalist paramilitaries. LGBT rights, welfare reform, the Irish language, churches. I've never mentioned churches. I've never once lectured Dr. Archibald on morality, and I never heard any member supporting this bill invoke religious belief as the basis for it. So some members have taken this debate well beyond the general principles of this bill. I sought, Mr. Speaker, to follow your guidance at the start and kept my speech very much in line with the general principles of the bill. I think it was Mr. Chambers mentioned how some members have spent more time attacking the messenger than actually looking at the message. But, Mr. Speaker, my own personal sensitivities are neither here nor there. And I've sponsored this bill, but I've done it on the basis of other MLAs. The Assembly doesn't allow multi-signatures on a private member's bill, because I asked and I inquired. Only one member can sponsor a bill. Or I would have had other members to co-sign this bill with me. So this bill is much more representative than me as an individual, than the DUP as a political party. It's much broader than that. And beyond the party politics of this, Don't Screen Us Out as an organisation have led on this campaign. They don't take a position when it comes to the wider abortion debate. They don't describe themselves as either pro-life or pro-choice. And this is the organisation who is engaged with a number of members in this House and that has led this campaign. So I think members need to ask themselves why some of the members opposite singled out the DUP and used other issues to cloud what this bill is actually about. And I think it's important that we stick to that. I suppose I do, and I state the obvious. I speak on this as a male. I almost feel like I need to apologise for that sometimes. But I'm a father of 3 daughters. I'm a husband. I represent thousands of females that have voted for me. Does that make my voice less important just because I'm a male? Some members have seemed to indicate that no male member of this House dare ever get engaged on this type of issue. I say to members, we really need to raise the level of the debate when we're considering this. Because again, Mr. Lunn made the point, there's people outside this chamber are watching. My phone has not stopped with the hurt and the distress that has been caused to people, like Heidi Crowder's mum, who's been messaging me throughout this debate, devastated at some of the comments that members have made in the course of this debate. So there is an audience outside this place that goes beyond me, goes beyond the political parties that are represented, and we do need to take cognizance of that. If I went through every single member's contribution, we would be here a very long time, and I don't intend to do that. But I note that we have had 26 members of the Assembly contribute, 4 executive ministers, the First and Deputy First Minister being 2 of them. So there is no doubt that this very short bill has engaged a lot of interest across society and indeed within this House in terms of members' contributions. Let me just pick out a couple of things that I do need to deal with in terms of some of the inaccurate commentary around this. Some of the presentation that I made to the Health Committee, whether deliberately or not, has been misrepresented. Things that I apparently said I did not say, and the way it's been characterised by some of the members of that committee. I'm not going to go through all of the particular incidences, but there was certainly more than one. But the member for South Belfast, Ms Bradshaw, challenged the Assembly. Do we need another courageous woman to fight for their rights? Absolutely we do. And Heidi Crowder is fighting for her rights and the rights of people like her, and I commend her for it. Whenever we considered a lot of these issues, there were some general themes that members raised, and I do want to touch on them to assist folks in reaching their view. And I appreciate that there are some members who are waiting on my response to take their final decision on this. Others have taken a predetermined position in respect of it. And how a political party navigates their internal politics is not for me to get involved in. And I wouldn't seek to get involved in it as to what they're trying to do. Members have highlighted, I know, in terms of Sinn Féin's own position on this, it's for them to speak to it. I note they're going to abstain today. And I suppose there's some hope for me, because whenever we brought forward a private member's bill on the human trafficking bill, there was one element of that Sinn Féin at the start were reluctant to support. And once we got through the process, they came on board. But I know that the quotes attributed to Ms Sheeran, I don't need to repeat them because they're now on the record. Colm Gildernew, the chair of the Health Committee, who Heidi Crowder praised when she appeared before the committee because of what he said about her on the 2nd of June. And because in that debate, this is Colm Gildernew saying it, Sinn Féin does not support CEDAW's recommendation to provide abortion in cases of severe fetal impairment such as Down syndrome. Our amendment welcomes the important intervention by disability campaigner Heidi Crowder, who was referred to today, and rejects the specific legislative provision in the abortion legislation that goes beyond fetal abnormalities to include non-fatal disabilities such as Down syndrome. I support the amendment. That was the Sinn Féin amendment. They're choosing to abstain today. It's a matter for them. Issues have been raised in respect of justification for that around what happened with the mothers and babies homes, around commissioning of services, which my bill doesn't touch on, but that's been the main plank. And let me acknowledge injustices that have happened in the past. And I do want to touch on Sinead McLaughlin's contribution. And I could tell from listening to her, there was pain there in terms of her mother's own experience. I could feel it when she was speaking about that. But in that wider context of those injustices, that is not resolved by perpetuating injustice on our most vulnerable, those that have disabilities. So let's put right the wrongs of the past in terms of how people were treated, but let us not think that by keeping in place this regulation, it in any way deals with the hurt and the pain of what went wrong in the past. It doesn't. So, Mr. Speaker, some of the key themes that members alluded to, and I do want to turn to those now. Some members raised the issue about my consultation process. I think it was Mr. Muir indicated that he had concerns about the way in which I had consulted. However, went on to say that he opposed to the general principle of the bill. So whether it had been, in his view, consulted by the way he would want, he still would have opposed it, because that would have been the consistent position to take. Other members have cited that and indicated that I'm seeking to rush this through. I'm not seeking to rush anything through. It was introduced as per the normal procedures. The convention is 4 weeks. When it comes to the second stage, we have waited for 4 weeks. I have briefed the Health Committee. It is subject to the vote now in this Assembly. It then goes through the subsequent processes. Compare that to Stella Creasy's amendment at Westminster. No consultation at all. An amendment brought to legislation about the re-establishment of this executive. There was no engagement with disability rights organisations whenever this amendment was passed. None. Whenever the regulations were then produced and they were put through as statutory instruments to committees which weren't subject to any member of Parliament from our jurisdiction being part of, there was no consultation when those regulations were drafted and put through the system at Westminster. The NIO, yes, there was a consultation, a broad one in terms of that, of which 79% of those respondees said they were opposed to. So when members seek to use their interpretation of consultation and wanting to go through the normal assembly processes, I just say to you, and gently, the standard applied to how Westminster has dealt with this and cheered on by some of those who are now criticising my bill, cheered on, doesn't compare. It doesn't compare at all with the process followed by Westminster. Members have raised the legislative competence of this bill, and I don't intend to repeat. Obviously, the Health Committee got a closed session in terms of the legal advice from the Assembly's legal services on this. They're privy to legal opinion that I'm not privy to. I assume they interrogated that in detail. But that would have been the same legal opinion that comes through to the Assembly and the Speaker whenever I first put this bill forward before Christmas. It was subject to the normal considerations. I assume it was compliant because the Speaker allowed it to get to this stage. But I have got legal opinion on a whole range of things, and I've got legal opinion from quite a number of different Crown Counsel in respect of this that are supporting this bill. But whenever we look at this aspect about the legal competence, because I think some members have raised, Ms Sugden one of them, about if this ends up being judicially reviewed, it may well be. All legislation is subject to judicial review. That's not unique to passing laws. But that it's going to be struck down and it won't stand. Well, here's some Crown Counsel legal opinion in respect of the Northern Ireland Assembly. Let me read it into the record. Northern Ireland is not a member state of a federal union. A consequence of the present devolution settlement set out in the Northern Ireland Act 1998 is that both Parliament and the Assembly may legislate on the same topic, and that each legislature may repeal or amend the acts of the other. The Sewell Convention is designed to avoid such overlapping occurring in practice, at least as far as government legislation in Parliament is concerned, but that such an overlap exists is an obvious element of our constitutional law. That advice goes on to say none of the barriers set up by Section 6 of the Northern Ireland Act 1998 apply to the present bill. The bill deals with a transferred matter, i.e. abortion. Parliament has also dealt with that transferred matter, but that does not make it any less a transferred matter. It has not ceased to be a transferred matter. The Assembly is entirely free to amend the regulations in the manner proposed by the bill. So if it is subject to judicial review, I'm almost sure there's going to be, if there is, arguments in respect to that, but there's Crown Counsel advice, and hopefully that will reassure the Assembly's legal services that the advice, I assume, given to the Speaker is actually correct. Members also raised about international human rights legislation. I think it was the Minister, Deirdre Hargey, said that this was not in line with international human rights, and I think it's important that I just touch on that for a moment. Again, Crown Counsel legal advice in respect of this issue. I think it's Brett Lockhart QC, members will be familiar with. He gives me this advice. The United Kingdom has ratified the UN Convention on the Rights of Persons with Disabilities in 2009. The preamble at paragraph G recognises that discrimination against any person on the basis of disability is a violation of the inherent dignity and worth of the human person. Article 10 of the Convention reaffirms that every human being has the inherent right to life and shall take all necessary measures to ensure its effective enjoyment by persons with disabilities on an equal basis with others. Article 12 reaffirms that persons with disabilities have the right to recognition everywhere as persons before the law. And this is the United Nations Convention, not a committee, the Convention. The UN Convention on the Rights of the Child states that a child, and I quote, needs special safeguard and care, including appropriate legal protection before as well as after birth. UN Convention on the Rights of the Child. Before birth. Not just after, before. That's international human rights. This bill is entirely in keeping with human rights legislation. Then I think it was, again, I think it was the member for South Belfast, Ms Bradshaw, indicated that whenever this goes to the UK Supreme Court, it'll be struck down and the UK Supreme Court is going to rule against us. Oh, I would love to have such foresight. I would start playing the lottery if I knew exactly what judgments are going to be when it comes to these kind of things. But what the member for South Belfast doesn't say, and some other members alluded to it, wrongly in my view, but nevertheless, the Northern Ireland Human Rights Commission took a case to the UK Supreme Court. It sought a declaration of incompatibility on human rights laws, not just on non-fatal fetal abnormality, but also on this aspect, on severe fetal impairment. So I think that was wrong of the Commission, but it did it. They went to the UK Supreme Court and they lost. So we know what the UK Supreme Court will do, because there was a case brought by the Human Rights Commission which they failed in. And some members have aptly quoted some of the judgments that were read out at the time. Lord Mance, but in principle, a disabled child should be treated as having exactly the same worth in human terms as a non-disabled child. This is also the consistent theme of the United Nations Committee on the Rights of Persons with Disabilities, expressing concerns about the stigmatising of persons with disabilities as living a life of less value than that of others, and about the termination of pregnancy at any stage on the basis of fetal abnormality, and recommending states to amend their abortion laws accordingly. Lord Kerr said, the UNCRPD is based on the premise that if abortion is permissible, there should be no discrimination on the basis that the fetus, because of a defect, will result in a child being born with a physical or mental disability. That was a UK Supreme Court. In our own courts, this was judged upon as well. And it was Judge Horner, in a preceding judgment, said, I do consider that it is a legitimate aim to keep in place a prohibition on abortion where the fetus will be viable, but the unborn child faces non-fatal disability. There should be equality of treatment between, and on the one hand, the fetus which will develop into a child without physical or mental disability, and on the other hand, the fetus which will develop into a child with a physical and or mental disability which is non-fatal. So we have judicial decisions in this area of law that we're speaking about. And I think those judgments do go to some of the problem facing those that are trying to get around this issue that they're clearly wrestling with, around what's framed as the woman's right to choose. And to be fair to the Green Party, I don't agree with their policy, but their policy is quite clearly now in the record. It's the right to choose in any circumstance at any stage. That's the Green Party policy. So therefore, when it comes to this legislation, I can understand what the approach that they're taking. However, to be consistent on that, and to eradicate the discriminatory aspects of this law, which is what the United Nations Committee, by way of a statement on CEDAW and the UNCRPD, said, you just make abortion available at any stage, for any reason. Therefore, you eliminate the discriminatory aspect of the law that singles out somebody with disability. That would be a consistent position to take, that if you don't want legislation in this area which is against preborn babies with disabilities, then abortion is allowed in every circumstance, at any stage. Then you eliminate discrimination on the basis of disability. But you can't get round that. And this is the problem with those that have quoted CEDAW, and in terms of paragraph 85, which is the paragraph that blunt instrument at Westminster put in, because that paragraph actually recognises the conflict that exists in this area, which I note the Royal College of Obstetricians and Gynaecology actually omitted in theirs. But in terms of Article 5 of the CEDAW recommendation, and it is B3, which is the area that this bill relates to, severe fetal impairment, including FFA, without perpetuating stereotypes towards persons with disabilities. There's the key phrase in terms of the internal contradiction of paragraph 85 in CEDAW, they are advocating for abortion in cases of severe fetal impairment, including fetal, without perpetuating stereotypes towards persons with disabilities. This law does perpetuate. So therefore, CEDAW and paragraph 85 is internally contradictory. So this bill, one could argue, is entirely in line with paragraph 85 of CEDAW because it removes that contradiction in terms of the perpetuation of stereotypes with peoples with disabilities. Mr. Speaker, some of the other broader points that were raised by members in terms of this area, and we spoke about the disability discrimination laws. Some members highlighted this, and I think it's right that we do, because members have campaigned for equality of treatment, equality of opportunity. It's been at the core of some political parties' essence as to what they are. That's why we have the Disability Discrimination Act of 1995, but that's why we have Section 75 of the Northern Ireland Act, 1998, came about through the Belfast Agreement. And that Section 75 places a statutory duty on public authorities to have due regard to the need to promote equality of opportunity for persons with a disability. Part of the Belfast Agreement comes through Section 75, which I hear consistently from members on a regular basis. Then we also had the Disability Discrimination Northern Ireland Order of 2006, and that amended the 1995 Act. Again, that requires public authorities to promote positive attitudes towards disabled persons. How are we promoting a positive attitude towards disabled persons when, in and of itself, for no other reason, a termination of pregnancy can be granted because of a disability? That doesn't engage the mother in respect of that pregnancy. It is, in and of itself, a ground for termination. So, in our law, up to 12 weeks, termination can take place for any reason. After 12 weeks, there are 3 reasons on which a termination takes place: the mother's physical and mental welfare, fetal abnormality, and then this one on non-fatal disabilities. So, members, I don't know what more I can say around how this is against people with disabilities and flies in the face of international human rights declarations, how it goes against legislation passed by the Assembly in terms of disability discrimination. We have the UN Committee on the Rights of Persons with Disabilities. They have made it clear, and I quote, "That committee is concerned about perceptions in society that stigmatise persons with disabilities and about the termination of pregnancy at any stage on the basis of fetal impairment. The committee recommends," and this was to Great Britain, "amend its abortion law accordingly." Members, Great Britain, in terms of this legislation, when they first passed this and changed their 67 Act in 1990 in respect of it, this was before UN Convention declarations. It was before the Committee on People with Disabilities made their proclamation around abortion law. But now they have. And yet some members seem to advocate that I should look to Great Britain as a model and an exemplar. It's not. I have much more affinity with my Irish brothers and sisters in the Republic of Ireland on this issue than I do with anybody in Great Britain in terms of the political representation. I will look to Dublin more on this issue than I look to London. So the argument that some members make that somehow this is contradictory to unionist credentials, really and truly, this transcends that type of identity politics of whether you're unionist, nationalist or other. And for those that make that argument, is a very strange argument to be making. I'll give way to Mr. O'Dowd, yes.
A very detailed, interesting presentation from the member, but I'm always very cautious of listening to quoted or selected quotes from legal determinations, because you'll find over the page there's another legal argument that will actually go against you. But I'm sure that will all be sorted out at committee. If you want to follow your Irish brothers and sisters in relation to this matter, will you encourage your party to commission services that were acted in law in relation to this legislation that you're about to amend? I think that would be an important step. Maybe you'll come to Mr. Lunn's point where Mr Lunn has said that you have told him that this is the end of your legislative journey in relation to this matter rather than the start?
Can I thank Mr O'Dowd for that, and I welcome the engagement, and I do welcome, when I get to the Health Committee, being able to engage further with them. On those two issues, I think Mr Allister alluded to this. The bill is exactly as it says. It's the Severe Fetal Impairment Abortion Bill. It is a single clause bill, not for me to rule what will be within scope. But I don't believe this can be either added to or taken away from, unless you voted against. I don't see where you can do that. For my part, I'll not be bringing amendments to the bill. The bill is as it has been produced. What other members seek to do in another time and another place, I'll make decisions upon that at that point. But nobody, I suppose, in that respect, should be surprised at my position on the wider issue in respect of these matters. But that's not what this should be viewed upon in terms of looking at it as to what does Paul Givan think. The bill speaks for itself. On the other issue around the commissioning of services, again, I appreciate the member wanting to draw me into this. But this bill doesn't deal with the commissioning of abortion services. It's not part of the general principles of this bill. Where there's a discussion at the Executive, I'm sure my colleagues will facilitate that at the Executive. But on that wider point, it does go back to the way in which this legislation was brought in. I have some sympathy for the Minister for Health on this. I've asked numerous questions in writing to him. He has indicated to me that this legislation Westminster has imposed. So his position up until this point has been, well, then they should pay for it. Let's see how the Executive manage that particular issue. But that's not what my bill is about in respect of this. In terms of some of the other points that members raised, and I think Mr O'Dowd neatly brought me to the end of legal arguments in international human rights law and how Westminster has dealt with this. A number of colleagues have spoken about the different medical opinion on this and quoted the Royal College of Obstetrician and Gynaecology, Doctors for Choice. I dealt with that at the opening part of my statement. I appreciate not everyone will have been there for that. I put on record contributions that have been given to me in terms of medical professionals that have disagreed with that. I know we did get this letter that Mr Lunn spoke of. I understand that that is now at over 200, and whenever I say 200, that includes not just GPs, it includes consultants. So those that seem to proclaim to speak on behalf of the entirety of the medical profession and that somehow the Royal College is representative of them aren't listening to then those that are saying that's not the case in terms of the responses. And we have consultants in the Belfast Trust who have put on the record their position around this, in the Western Health Trust, and I can go on, and I did say that this extends to the sexual and reproductive health care, palliative medicine, emergency medicine, general surgery, psychiatry. All of those medical professionals are saying, support this bill. We support this bill. So those that are advocating that they should be against it because of the medical profession are closing their ears to that different opinion that exists there. I accept there are those within the medical profession who are advocating against this. I don't deny that. But neither should members deny that there are significant numbers of people within our medical profession who are asking for this to be supported. The letter that was sent to members, I suppose I should not read it all, but it's worth putting it on the record, the opening paragraph. And the open letter read, and this is now signed by over 200 doctors, consultants, medical professionals. We read with real concern the submission to MLAs presented by the political advisor to the Royal College of Obstetricians and Gynaecologists. There can sometimes be a tendency for doctors or doctors' bodies to give the impression that there is a unanimous medical view which should be respected, or even the impression that a body's members have been consulted on topics such as these. We, the undersigned, are all doctors who fundamentally disagree with the contents of the ROCG submission. It is, of course, the right of the political advisor to the RCOG to make a submission to MLAs, but it is also our right as doctors caring for patients with disabilities to do the same. Some of the other issues raised by members in terms of this issue spoke about where the public are in terms of this. And again, Mr Lunn, he pointed that he doesn't always go in line with public opinion, and neither do I. I suppose that's something we have in common. If we hold a conviction on an issue, we're going to keep to that, and I do, as do others. But it is worth again noting that there has been a public petition for this private members' bill. I think it's the highest ever responded to. 26,814 people have signed it, calling on the leaders of the political parties to support the bill. We've also had 1,618 people with Down syndrome and their families calling for MLAs to support this bill. We've had 200 plus doctors now asking us to support this bill. But there was public opinion polling carried out by Lucid Talk on this issue as well. And it's interesting, again, members sometimes will seek to represent their constituency, even if that doesn't necessarily correlate with their own opinion, but they see their role as being representative of their broader constituency. There's a specific question polled for, and this is only going back to June last year, and they were asked the question around abortion for those with Down syndrome and cleft lip, and in those two areas there was only 20% of people that said they supported the law. Only 20%. 80% either oppose it or didn't have a view. The overwhelming majority opposed it. On the issue of cleft lip, only 15% supported it. The overwhelming majority were against it. So if members want to represent wider public opinion, I appreciate we all need to be influenced by legal issues and in terms of courts and international human rights, but I believe that we have the law on our side. I believe we have international human rights on our side, and we also have public opinion on our side in respect of supporting this bill going through to the next stage of the process. And I hope that in that engagement other people will come on board. I think, Mr Speaker, I have covered as many issues as I wish to do so. Please don't, members, think that not name-checking you or addressing your specific issues that in any way I'm being disrespectful. I wouldn't want any member to do that. But obviously I would hope that we can move this on into the next stage of the process. It does go into the committee stage process when obviously the committee will then be in a position to put that out for a wider call of evidence, and different people can respond to it at that particular stage. So, Mr Speaker, I trust that these issues have been covered in as much detail as I can possibly give them, and that I've given due courtesy and respect to everybody, even whenever they have disagreed to me. And I commend the second stage of this bill to the House. Thank you, Mr Speaker.